Adjournment request, if any, from item number 1 to 9. From item number 10 to 18.
Lordship, with regard to item number 18, Lordship, Learned Senior Counsel is out of station, Lordship. May I pay the matter may be adjourned for the day, Your Lord.
Adjourn.
Lord.
September.
From item number 19 to 27.
Adjourn to September. Yes. My lord, item number 22, my lord, we need a little accommodation. 22. Because the appellant side, my lord, filed one additional affidavit, my lord. So we need to have some instruction from our side. You are for? I'm for the other side, my lord. Respondent number 4, man. Respondent number 4, man. The request is made on behalf of the council for the respondent number 4. For the time wait for filing rejoinder. They are in response to the counter filed on behalf of the appellant.
Yeah, fine, my lord.
Time paid for is granted August. Yes, deep level.
My lord, if the date can be postponed slightly to the month of June, my lord, I implore, my lord.
May I please, Lordship. My lord, I beg to mention item number 24, my lord. My lord, I'm for the appellant, my lord. My lord, I pray for adjournment only for the day, my lord, today. Due to some personal problem of my senior, my lord. And next week, any day, my lord.
In fact, it's a Manipur matter.
Yes, my lord.
So how this writ petition is was maintainable here? Learned single judge has rightly said all the causes of action arise in the Manipur.
Well, the petitioner was residing in the state of Assam, my lord, and
Simply by whatever the order against you was passed by the Manipur, the officer at Manipur, the proceedings, whatever they have culminated there in Manipur,
my lord.
simply because you are temporarily residing here, how it is maintainable? That is learned single judge is rightly here.
Maybe listed next week, my senior will add.
Next week.
Yes, my lord. Obliged, my lord.
May I please, Your Lord? I beg to mention item number 23, Lordship. We have 23.
Adjourn.
Interim order may come.
Who is for the
May- Yes.
interim order? You need to continue. Adjournment slip is circulated. Yes.
May I please, Your Lordship? In item number 26, we need some more time to file the reply.
There is no need. They have already issued a prohibitory order. We'll pass an order.
My Lordship, they have or issued the prohibitory order in regarding with the post PIL, Lordship. It is not regarding with
Whatever
the.
it may be, the prohibitory order is there. Your concern was that in the earlier PIL, there was an order and the state government is not taking any action.
Yes, Lordship,
So, We'll pass
I
an
may be
order.
given. May
We'll pass an order. Ultimately, it's a PIL. Yes.
He was my junior. He is my junior, Lordship. Just first
Yeah,
time.
so what
Lordship,
wrong he has
Lordship.
mentioned?
Lordship, thing is, Lordship, they have built certain constructions are there,
We'll
Lordship.
consider it. Let the number comes.
Lordship.
Let the number comes.
Lordship.
May I please, Your Lordship, I beg the item number 31. The matter may be adjourned for the day. Learned senior Angus counsel is out of space.
Is made list in August. Yes.
May I please, Your Lordship? My Lord, beg to mention item 29, my Lord. I paid for adjournment for 3 weeks, my Lord, because of my health issue, my Lord.
Why?
Because of my health issue, I could not get ready, my Lord.
Wrestling तो करनी नहीं है आपको. Argue ही करना है.
My Lord,
You have to argue only. Wrestling थोड़ी करना है जो you are not prepared.
because of my thought problems, my Lord, I cannot argue my health today.
Then made request is made list in September.
Any other request? Daily list for orders, item 1.
May please, Your Lordship.
Lordship, I may be allowed to take Dusty, my lord, upon respond number 5, 6, and 21, 8 and 21, Lordship. Sorry, Lordship, I could not take up step as per the order of Lordship, order, my lord.
Thrice,
Yes, my lord.
thrice.
I
by the
apologize, my lord.
Lordship order.
I apologize, my lord. I will be taken one day time to
Clear.
1 day time, Lordship. So that's still
As
okay.
per the Lalima court order, the petitioner, the counsel for the appellant has failed to take steps for service of notice upon the respondent number 5 to 21, 5, 8 and 21.
Yes, Lordship. That's already served, Lordship.
5, 8 and
My
21.
lord, 6 also, Lordship.
Despite several opportunities granted to the, despite granting of several opportunities, full stop. Learned counsel for the appellant raised for one more opportunity to respondent number 6 only, not 5, 8 and 21, only 6. The concept of the appellant raised last opportunity to do the needful. In the interest of justice, last opportunity is granted to do the needful. With this understanding that no further opportunity would be granted.
Obliged, Lordship.
List after 4 weeks.
Item 225.
So you were supposed to file latest.
Yes, Lordship, I apologize, Lordship, but my friend was not available for serving copy, Lordship. I could file it only today morning, Lordship.
Should supply my copy.
Yes, Lordship, today
Great.
morning.
Okay. Learned, counsel Mr. P. Nayak has submitted that the latest factual report is filed today only. Full stop. The same is not available on record. Registry is directed to bring the said report on record and list this matter after 2 weeks. In the meantime, if you want to file any response, you may file.
Lordship, in the meantime, Lordship, may I pray, Lordship, that the first matter be segregated from the others, Lordship.
Why?
The first matter relates to congested footpaths, Lordship. It is not conducive for the elderly persons. That is the issue in the first case, Lordship.
So it's interlinked matter because the vendors are on the footpaths.
Yes.
So it's an interlinked matter.
So the petition, livelihood have to be taken into consideration. We are not against the livelihood of
We'll
the
consider-
vendors.
That's why only we have directed,
Yes, yes,
create a separate zone for vendors.
yes.
That is what.
Obliged, Lord.
Item 6.
Service in respect of respondent number 2 is not complete.
Not complete, my lord. It was awaited on the last occasion, my lord.
It's not complete. Take fresh steps.
My lord, my lord.
Okay, as per the office report, notice upon the respondent number 2 has not been served till date. The net counsel for the appellant is directed to take fresh steps for service of notice upon the respondent number 2, respondent number 2. Requisites by through registered AD and so, register the requisite be filed within a period of 3 days. On filing of the same, let notice be issued to the returnable 6 weeks.
Item 7.
So is for the state,
My lord,
who is for the state? Item number 7, this item number 7. Service not
my lord,
complete. for-
service I have already filed in the way of affidavit on 2nd of May, my lord. In
In the May.
2nd of May
Available.
with the check consignment. That
You
is
are
not,
appearing
that
for
is not with the
Mr.
record, my lord.
Mister. You are appearing for whom?
Lordship, I'm appealing for respondent number 4 in respect, Lordship, for the finance department, Lordship. Lordship,
That affidavit is not available on record, sir.
My lord, that is not available with the record, my lord. I have filed on the 2nd of May, my lord.
7th of May
Second,
is not on record.
2/5/2025.
The notices have been served upon the respondent.
My lord, all the response already delivered.
Okay. Learned counsel for the, as per the office report, the notices issued to the respondent number 1, 2, and 3 have not been served till date. However, learned counsel to the commissioner has submitted that he has already filed an affidavit in respect of the service of the respondent number 1, 2, 3 on 2nd of May 2025. The copy of the said affidavit is not available on record. Registry to check, registry to verify, and if such affidavit is filed and the service, and as per the same, service of notice upon the respondent number 1, 2, 3 has been affected. Place a note of this effect in the place in made a remark of this effect and place this matter before this court after 2 weeks.
Obliged.
Item 8,
8 and 9,
Lordship, service is awaited upon the respondent, lordship.
they have already filed this item number 8. Service is complete in respect of 1 and 2.
As per office note, the 9/5/2025, lordship. Item number 8, lordship.
Yes, sir. It's not like it. Await return of notice of respondent number 1 and 2 for 3 more weeks.
Oblige, your lordship.
item 9,
Well, in item number 9 and 10, I'm appearing for 1 and 2. Well, my instruction is that the state has decided to prefer it as SLP. Well, I need some time. Well, I'll file an affidavit indicating the steps taken.
SLP, if you are filing or proposing to file an SLP, that can't be a ground for not complying with the order of the
Well,
court.
I'll file an affidavit indicating the steps they have taken. Well, so far.
Whatever the steps may be, even though if you are filing affidavit of this effect that we have decided to prefer an SLP, that can't be a ground.
But
That can't be a ground for disobeying the order.
I have
Until and unless that order is reversed, stayed or something else.
that's true. But so far, this is my instruction. Kindly give me some time. Well, I'll file an affidavit to that.
Find it. Instructions, nothing to it. Then it consent for the.
For the first time, madam, I
Mr.
have
Also put in appearance on behalf of the respondent number 1 and 2.
1 and 2.
Only 2 respondents are there.
2 respondents.
All the respondent, on behalf of the contenders. He placed some time to file counter to the contempt, placed some time to file reply to the contempt petition. Time period is granted list after
Lordship, 3 weeks. 3 weeks. Lordship, 3 weeks.
2
time.
weeks.
Lordship, 3 weeks time. I will give.
2 weeks.
Hold on.
item 11,
No steps have been taken.
Also, I'm paying for withdrawing of this appeal, Your Lordship.
This means, Nikhil, and counsel for the petitioner that placed for withdrawal of the IA number 4712/2025 under section 5 of the Limitation Act. Full stop. The player is accepted, IA number so and so is dismissed as withdrawn, resultantly, the connected writ appeal, this writ appeal number so and so, connected writ appeal number 13683/2024 filing number is also dismissed as withdrawn.
item 12,
That I am unable to take step as my last order, lordship.
1 and 2, you have not taken any steps.
I may be allowed to take it, sir. I apologize for that.
As per the office report, steps for service of notice upon the respondent number 2 has not been, no steps have been taken for service of notice upon the respondent number 1 and 2. Learned counsel for the appellant raise a week's time to file the requisites for service of notice upon the week's time to comply with the order dated 21/2/2025 on compliance of the same, let notices be issued to so and so and returnable on so and so.
Obliged, sir.
Item 14.
Lordship, in this case, notice was returned answered.
Sir, how many times
No, Lordship, there.
the Laujima court has granted you time? How much,
Lordship,
how much time?
Lordship, on two occasions, Lordship, we could not.
Why you are not appeared before the
Lordship,
Laujima court, sir?
That was Lordship, our mistake on our part, Lordship.
Despite granting several
Lordship, now we got the.
why, despite granting two opportunities by the Laujima court, no steps have been taken for service of notice upon the sole respondent.
Sole respondent, correct address.
Sole respondent. Full stop. Learned counsel, Mr. Kyle prays last opportunity to take steps for service of notice upon the respondent, sole respondent by registered AD post, registered post AD within a period of 2 days.
Lordship, on correct address. Earlier, Lordship, return
Whatever
answer.
it may be, on 2 days. In 2 days, time paid for is granted. On furnishing the details, on furnishing the requisites, notices be issued to the sole respondent, returnable 4 weeks thereafter, 6 weeks thereafter.
Lordship.
Item 14.
No fresh address is supplied.
Lordship,
No fresh address is supplied by you.
no, Lordship, in this case, your Lordship, item number 14. Then I has been filed for staying of the process of the new fresh
Item
tender
number
process.
14.
Lordship.
Okay, yes.
Here, your Lordship, what has happened as per my instruction, the new tender process has been put on hold in terms of the last order, your Lordship. So the matter may kindly be taken up next week for final disposal.
2 weeks. At the request of council for the after 2 weeks.
Item 15.
They have deducted, then what, now what can we do, sir?
Your lordship has to direct them to redeposit the monies. Your lordship's order, they have flouted
Once they,
and they have done it stealthily without even informing us.
so that's that may be a.
Their whole conduct, my lord.
Refund of the order, once it is deducted, then would be very.
No, that is in violation of your lordship's order.
So order is of 14/5
14/5
and they
And-
deducted it on
and
9.
on 9th, but 9th, I'll just give your lordship few dates. 9th we filed.
You have filed and you offered them this red petty copy of the red petition, they refused to take.
Yes, that is one. Thereafter, my lord, we got your lordship's order on 15th. 14th, your lordship passed the order, we got it in 15th. That was also communicated to them, to the respondents.
But they, as per their.
And so far
whatever
as the
letter-
9th letter of theirs is concerned, 9th, they have deducted the monies from both banks.
Informed you,
And they, by a letter, they say of 9th, they informed us.
you. are in
That
district
letter
court,
we
letter on
received on
16/5.
16th. Now we have, she has trailed it's a speed post letter. They have posted the letter on 14th. Although letter is dated 9th, it is posted on 14th and we got it on 16th.
Who is appearing for the bank?
I don't know, but it's absolutely a design thing to take the money out without, even a SMS is not, entire money is taken out from the this SBI. And there is nothing, we come to know because a 5,000 check was given to one of our employees, it was dishonored. Then only we have come to know. Is that the way you treat? This you sent on 15th. Yes.
Let the response be done.
Your lordship will ask them to appear before your lordship.
Who is the counsel?
The Southbound, South Guwahati SBI, respondent number 2 and 3. NCTAO.
Of this IA to the respondent, number 6.
That, Milord, the respondent number 3,
Who is the 3? Assistant General Manager. He's the
Lokra, 3 is the assistant general manager who has given the letter on 9th.
He's the one.
He should come before your lordship and to explain why he did this.
We don't know.
It is not I mean, your lordship's order is there.
Let this notice, let notice of this IA be issued to the respondent number 3 and
3, then 6 and 2.
who is 2?
2 is the Delhi.
Why you are this New Delhi?
Anyway, Milord,
takes some time,
respondent number 3 and 6.
3 and 6
No.
for the time being. Returnable on
Friday, Milord, let it come to Friday. Subject to your lordship convenience.
returnable on 4th of June through the registered AD and Dusty. 4th of June.
Milord, 4th of June will be a little too late. Let them come and explain first.
4th
Why
of June.
they have, Milord, one account has become 0. And the other account, which was not in the picture at all, how can that account release the balance amount of 18 lakhs?
We'll ask them, that's why.
And they have sealed the account also. Huh? Which one?
Keep it on Friday.
Your lordship will keep it on Friday, ask some of them to come.
The day after tomorrow.
Yes, or have it on Monday, then
You will not be able to, you will not be able to get them, sir.
we'll serve it today itself. Trustee,
Something very serious.
Okay,
this is something you can't expect a bank to do like this.
28th of May, 28th of May. 28th of May, returnable on 28th of May. You registered AD and Dusty. Wednesday, next Wednesday, sir.
They have already received notice. We have sent the order of your lordships, Milord. Therefore, they should come and tell your lordships why this is done.
See on
Have
28th
it
May.
on Monday, Milord, next Monday. We will serve it today itself.
48.
We will
Then
serve
they'll
it.
come and ask for some time.
No, they have to explain, Milord.
26th May, 26th May.
Item 16.
Publish.
Lordship, before my learned friend commences, let me submit your lordship. We have not been served with notice, your lordship. We have not received formal notice, your lordship. We have not received the appeal memo also, your lordship. But because my pension was not released, your lordship, I went to the university to inquire about the fate of my pension, your lordship. That was not paid, and they have said that because of this appeal, my pension has been withheld.
Yes, stay order is also there.
But then this matter, your lordship, is not concerned with pension, your lordship. This matter relates to back wages, your lordship, during the period of the original penal order and the subsequent penal order, your lordship.
Respondent?
Sole respondent, your lordship. So direction may be issued to pay me the pension forfeit, your lordship.
We'll do that.
Let,
ensure that.
you,
And I'm going to submit a copy of the appeal memo, your lordship.
Today
first
itself, I'll
will
give.
serve you the copy, it's though the notice issued to the respondent number, though the respondents have not, the appellants have not taken any steps for service of notice upon the respondent, you have not taken any steps.
That's the worst. I'll confirm, my lord.
Not taken any steps for
The morning
service of
also.
notice upon the respondent number 1. However, however, Mr. So-and-so has put in appearance on behalf of the respondent number 1. Service is therefore complete. Copy of the writ appeal along with the requisite documents, along with the documents we supplied to the council for the respondent number 1 during the course of the day. List this matter on 2nd of June.
If possible, we will file our affidavit, your lordship, if possible.
We are, it is always open, we are not restricting.
We may not be able to file our response, your lordship, within this period, your lordship.
So,
It might take some time, 2 weeks maybe, your lordship, maybe after 2
in
weeks.
fact, if this order is to be passed, that the pensionary orders are to be released, then why don't early date?
That's all right. Your lordship.
You are ready for that?
Manoj, we'll release the pension. We are, even in the writ petition, even in the impugned order by the, which was passed with the department, we had said that we will release the pension orders by taking notional benefits. If that has not been done, Manoj, I'll take it up personally. Pension will not be stopped. That I assure to be, sir.
Sir, otherwise order is only this, the finding of the learned single judge, while impugned order to pay the respondent the subsistence allowance by treating him in service is not liable to be
Yes,
sustained.
otherwise the pension had to be paid. I'll take my instructions on why it has not been released. There can be
In the
no
meantime,
stopping of the pension.
the effect and operation of the impugned order passed by the learned single judge to the extent of directing the appellants to pay subsistence allowance to the sole respondent, how can you state?
I'll have my instruction. I was not in the know that pension is not being granted. I'll have it instructions. I'll have it released immediately. Pension will not be stopped.
Copy of the writ petition so and so is supplied to the counsel for the during the course of the day. Learned counsel for the respondent has submitted that. So this court, by the order dated 18/12/2024, has stayed the impugned order to the extent of directing to the extent of payment of subsistence allowance to the sole respondent for the period that is from 31st of December 2004 to 2nd of November 2016. But in the garb of this order, the appellants have withhold the pension of the respondent. Full stop. Learned counsel appearing for the appellant has assured this court that in the garb of the order dated 18/12/2024, the pension of the respondent will not be stopped and the regular pension, including the arrears, would be paid to the petitioner at the earliest, in view of the assurance given by the learned counsel for the appellants. And as the matter is already admitted, list this writ appeal for hearing.
Lordship, the current pension may be paid forthwith, and about the area, your lordship. That may,
We have already
Okay.
assured us.
okay,
And if they don't do it, move an application, will pass it on.
Obliged.
obliged.
In due course.
Item 17.
Lordship, we have filed the rejoinder affidavit, lordship.
When,
We filed the rejoinder affidavit. lordship.
when,
Today itself we have filed, lordship, morning. We have given them copy, lordship.
PK learned counsel. For the petitioner has submitted that the rejoinder to the affidavit in opposition filed on behalf of the state is filed today only. So, just after 2 weeks.
Of the lordship.
Obliged.
Item 19.
Arunachal and Nagaland. Yes, Arunachal and Nagaland.
Lordship, we will be filing it during the course of the day, Lord.
And who is for, you are for,
I am for Arunachal, Lord.
who is for Nagaland?
Lordship, Nagaland Council, he was appearing, he is out of station, Lordship. He has informed me that
they will also be needing some time to file the affidavit.
How much time has passed? You have to file the reply at the earliest.
In respect of High Court, we have already filed, my lord.
Okay. Response on behalf of on the last occasion, this court has observed that response to the PIL petition is not filed on behalf of the state of Nagaland and Arunachal Pradesh. However, the concept for the Arunachal Pradesh has submitted that they are going to file response to this PIL during the course of the day.
Lordship.
During the course of the day. Full stop. It is also informed by concept of the state of Arunachal that the concept of the state of Nagaland is not available today. However, she has informed him that they'll file response of the PIL.
Lordship, no time has been told me to, but
They'll file response to the PIL very soon. Full stop. They start to 3 weeks. Inform of 3 weeks. Within 3 weeks, file the reply.
Item 20.
No trouble, no trouble, no trouble. Well, I have prepared a note. May I request your lordship to go to the site? Yes, sir. Open up. Okay, sir.
But now they have stopped issuing this certificates on the basis of this recommendation of tribal sangha or whatever it may be. They've already issued because now the certificates are being issued on online.
No, no, the certificate has to be issued on the basis of the recommendation to be made by the tribal organization.
No,
Uh,
that they have stopped it.
No, no.
Yes,
If they stop it, no problem.
yes,
Because I invite your lordship
Yes.
to go to page 170.
yes.
Yes, that has been stopped and online system has been introduced.
Now we are not
Right.
issuing any certificates this on the basis of this recommendation of the tribal organization.
No.
Are you sure?
Yes, he is representing the tribal sangha.
Yeah,
there is a notification of 22. Which states that the fathers and mothers who have caste certificate, they can.
what
apply online.
notification?
We are consulting the order. 24th, 16 March 24. 174 page. Okay. If that is all right, then my problem will be solved.
Down below.
এইটো কাৰণে ময়ো প্ৰিপেয়াৰ কৰা নাই after the order to come.
This, you're agreed by what?
The order dated, Annex 21, page 174.
Yes, what's wrong with that?
By this order, beloved, the executive power has been vested to a tribal organization.
No,
Which,
this is not there. Where is the executive power invested in?
yes, no, there is an executive instruction. In this regard, paragraph 2. In this regard, it is clarified that change of subject does not necessarily change the caste and sorry. All Assam tribal Changa and its district units have been authorized to make recommendations. Authorized to make recommendation for the issue of caste certificate for scheduled tribes in Assam. So this is the authorized.
They'll recommend only, they'll not issue caste certificate.
Yes, they will recommend only.
Caste certificate is to be issued by
But
the
this
district
recommendation will come within the purview of the executive order. Lord.
No, sir, that can't be, sir. That can't be, because this 22 notification is already there, which says applications are to be submitted by filing up online application form and attaching either the caste tribe certificate of the father of the applicant or an identification certificate issued by the authorized caste tribe organization. The deputy commissioner concerned, where the applicant is a resident, shall scrutinize the application, and when the caste certificate of the father or applicant is enclosed, is found to be genuine and bona fide, the deputy commissioner concerned may issue the caste certificate to such applicant.
No, we make a, the deputy commissioner by the.
Even though if they recommend, it doesn't mean that they are issuing the caste certificate.
No, but he has to act upon the recommendation of the tribal organization. That is totally an executive power.
He has to follow this guideline, sir. And 22 guideline.
No,
Even though if there is a recommendation by the tribal Sangh, he has to inquire into it, then only he can issue the notice.
But the guidelines are concerned, Supreme Court has specifically given a guideline in the Madhuri Patil case.
So that is
In that
regarding
case,
the
Lord-
inquiry into a caste certificate.
No, in that judgment, your lordship, paragraph 13, Lord, I have
Yes,
quoted
yeah.
this paragraph, Lord. All those things has to be done by the government machinery, Lord.
Yes. So that doesn't mean, sir, that is, even though this order is there, it is not diluting this notification dated 22.
Yes, in fact, my lord, whenever some complaints are received regarding issuance of the caste certificate, always makes inquiry by the concerned authority, my lord.
There. And we can't put a blanket ban as prayed by you in the writ petition, sir. That no caste certificate be issued.
No, caste certificate may be issued by the government machinery, Lord. But under what authority they are authorized to give a recommendation, Lord.
Sir,
That is
otherwise, what
totally
is
an
the-
executive
Sir,
domain.
otherwise, what is the mode with the government to ascertain whether a person is a tribal or not? Somebody, some association has, or some person has to recommend it. For the purpose of inquiry, this is reasonable, sir.
Government has their own machinery. They have their Mondol,
What
Lat
machinery
Mondol,
the government
Mojadar,
has?
etc.
Only
They
on the
can take
basis
the
of evidence.
information. Because only on by dint of their recommendation,
Sir,
the government has to
It,
authorize.
it may be counterproductive because any person, if applies for a caste certificate with an affidavit, yes, I am so and so, then the government is bound to issue.
By, the government is bound to verify it.
From
But
whom?
by his own machinery, my lord.
That can't be there.
Here's the Mandal, here's the Gambuda, all these things are there. Why they will
Then
take
why
the
not
course of a
tribal sangha?
recourse of
Why
a
not tribal sangha? That is. And your prayer is this,
my
it
prayer
is
is
there
at page number 29.
28, first read 28. It is therefore prayed your lordships may please to issue rule, call for record, call upon the respondent to show cause as to why respondent number 227 shall not stop issuing STP certificate to the persons of Sarania community not notified under the Constitution of India and also so called by the instruction issued by so and so, certificate shall not be set aside, quashed, and after showing the perusal of the record after hearing the parties be pleased to direct the respondent as follows.
Hmm.
So, sir,
Let's so far paragraph 1.
when the government has already clarified in respect of this Sarania communities, why this 16/3/2024, what's wrong with that?
Prohibit all Assam tribal Sangha from identifying and recommending the person from issuance of STP certificate and to follow the requirement. Set aside and quash the instruction dated 16/3/24 issued by General and 26. That absolutely have to depend upon the recommendation to be made.
27/6/2024.
Page 175, Lord. Page 175 and 174. Third line, fourth line. All Assam tribal Sangha and its district units have been authorized to make recommendation for issue of the caste certificate for scheduled tribes in Assam. So whenever all Assam tribal Sangha, upon satisfaction after due verification of the caste identity application and her parents, including the family history, records, etc., give their recommendation that the applicant actually belongs to the Kashari or Bodo tribe by birth, practice, etc., originally, then issue caste certificate in such cases may be considered.
Considered. Only consideration, they are not going to issue any certificate.
So only on the basis of their recommendation, the rest of the
Sir, this says affidavit has to also be filed, sir. Father's certificate is also to be filed. This procedure says.
All Assam tribal Sangha on satisfaction after due verification, the caste identity the applicant and which are, those are other information, right?
What was the earlier, this order of 2021?
Because what is happening. Madhuri Patil, page number also. 73.
This very issue you have raised in the earlier PIL petition. And they, this court has taken into consideration that.
Paragraph 8 and 9.
That is very, this this very contention was there and the court has dealt with and gave a finding that it is in accordance with law.
Yes, my lord.
So
My
now
lord, so
again,
your
again,
lordship may
yes, that-
kindly,
Sir,
my lord, so far the Supreme Court judgment is concerned.
sir, kindly come to page number 83 of your appeal.
Single bench judgment.
Division bench judgment, PIL.
Page 83.
Paragraph 8.
Yes,
Considering the aforesaid clarification given by WPT and BC Department, which is subsequently being renamed Tribal Affairs Department, we are of the view that the said process, if adopted, would
now,
not.
sorry, just a minute for interruption.
Sorry.
Para number 7, sir.
It is stated that although the notification dated 22/6/2009 had authorized that the President, Vice President, All Assam Tribal Sangha District Unit, Assam Tribal Sangha to identify the status of scheduled tribe communities and to issue certificate STP and STH in Assam, but the respondent in the WPT such and such department, which is subsequently renamed as Tribal Affairs Plain department had sought to involve all Assam Tribal Sangha in the matter of issuing certificates inasmuch as all Assam Tribal Sangha have better knowledge from the field level as to which the person may belong to STP and STH communities, and therefore their expert knowledge in the field is being utilized in the nature of preliminary inquiry in the process of issuing certificate. Because I have gone through judgment. Now, your lordship may
Now
please.
8, now 8. Now please 8. The observation of the learned single of the division bench. Para number 8.
Yes.
Read.
Next page.
Considering the aforesaid clarification given by the WPT and BC department, which is subsequently being renamed as such and such department, we are of the view that the said process, and if adopted, would not contrary to any provision of any other law, if the exercise is limited to the extent of making preliminary inquiry as to which person would belong to the tribal communities for being entitled to the certificate of their status. But at the same time, we also provide that contents of the preliminary inquiry that may be made through the All Assam Sangha shall not be constituted to be final matter for the Deputy Commissioner or Deputy Collector or the Revenue Subdivisional Officer for issuing the certificate, and as such, the authority shall also make their own application of mine based upon the materials that may be available for issuing the certificates. If you go, all right, now we also come to page 73, the Supreme Court's guidelines.
Sir, this matter was very well raised by you. This Madhuri Patel argument was raised in this PIL and the court has made this observation. Now, whether how it is now open for you to again challenge the same issue, sir, that don't rely on the recommendation of the tribal sangha, whereas the division bench has said, yes, if that procedure is adopted, it is not against any other law. That point has already been considered, which now you are again raising. This is already considered by the division bench of this court in the PIL, sir. The same issue. And the court has made it clear that it's only a recommendation. Ultimately, after due inquiry, the certificate is to be issued. That is there.
No, that order could, so far this observation is concerned, that was made with regard to the notification dated 22/6/2009.
So it was also similar where the government has authorized the tribal sanghas to give this certificate. Then the court has observed that this certificate would only a recommendation and not more than else. It can't be treated as final opinion.
After that notification, this order was passed in the year 2024.
The same order, sir. almost same order that they will recommend. And if I am not wrong, who
174 page.
Mr. S. Chauhan, Mr. D.C. Das, Learned Senior Counsel, assisted by Mr. S. Chauhan, you assisted in that case. So the same issue which was raised now, this has already been decided, sir.
After observation, my lord, so many recommendations are there, my lord, and my lord on.
Sir, recommendation, if you find that ultimately if a certificate is wrong, you can very well apply for cancellation of those certificate. We can't put a blanket ban. Because this, whatever the method, now they are adopting, it is already recognized by the court.
My lord, after passing the judgment, my lord, without my lord, your own scrutiny, my lord, or only on the basis
So
of.
then, if you are aggrieved by any certificate, the procedure is already there. You can challenge that validity of that. How can we put a blanket ban as you are praying in this? Sir? That no recommendation of the tribal sangha can be considered, sir. They are the experts, they are having the knowledge, they issue a certificate on that, yes, he is the tribal or not. Otherwise, what is the mechanism with the government to ascertain that who is the person belonging to ST community or not? Otherwise, they'll only depend upon this affidavit of the person.
No, they can investigate through their own machinery.
How can you, in each and every case, what is the method of investigation? What is the procedure? Can't be a straight jacket formula, sir. This order dated 16th of March 2024 and 27th of June 2024 are the verbatim same. What is the difference between these notifications?
What was dated? 2022.
174 and 175.
Same, same,
Same,
same, same.
same.
No, we don't know identical. It are the same. Happy, yes, it is. Happy. It was fine. It was fine.
The total
I'll leave it to your ocean.
will pass an order. This PA petition is filed by the petitioners being agreed with the this PA petition is filed by the petitioners claiming the following.
Modify.
This, you have also challenged the 10th of March 2024, which is that order?
Tenth of March or 1st March?
Sir, in the prayer,
Oh, 10th of March.
which is that order?
10-3, 2024. Connect with them. 10-3. Wait.
I think so. There is no order of 10-3.
10-3, not command again. Administrative. No, 10-3 probably is a typing mistake, Lord. But letter 10-3, we have not annexed.
It seems 16-3.
16-3. 16-3, no?
But with the following prayers. Stop. It appears that
16-3 page number.
174.
Go in the opening para of the prayer, the
We take 75 page, na? 175 page.
petitioners have mentioned regarding a instruction issued by the state government, white letter dated 10/3/2024. However, most of the instructions have been issued by the state government, and it appears that and 10/3/2024. But the instruction is dated 16/3/2024. Be that as it may, this court wide order dated. This court on 17/3/2025. 7/3/2025 has expressed its reservation in granting relief to the PL petitioner as prayed for because in the opinion of the court, no blanket order can be issued restraining the respondent authorities not to authorities from issuing STP certificate to any individual belonging to a scheduled caste community. The court has also observed that if the petitioners are aggrieved by issuance of STP certificate in favor of any individual belonging to any particular community, they are free to challenge the same before the appropriate authority authorized to verify the genuineness of such certificate. On that day, learned counsel for the petitioners placed some time to complete his instruction. Later on, again, some time was sought on 17/3/2025. Stop. The petitioners are essentially being agreed with the instructions issued by the state government dated 16/3/2024 and 27th of June 2024, annexures 21 and 22 of the writ petition, wherein it is clarified that wherein it is mentioned that whenever all Assam tribal Sangha and its district units, whereby the all Assam tribal Sangha and its district units have been authorized to make recommendations for issue of caste certificate for scheduled tribes in Assam. The said recommendation in Assam, after recording its satisfaction regarding the case identity of the applicant and his oblique her parents, comma, including family history, comma, land records, etc. Verifying that the applicant actually belongs to Kachari or Bodo tribe by birth, practice and ethnic originality, then the such recommendation shall be considered for the purpose of issuance of caste certificate. Full stop. It is noticed that the state of Assam has already issued guidelines through office memorandum dated 8th of August 2022. Laying down the standard procedure for issuance of scheduled caste, scheduled tribe and other backward classes / more backward classes certificate. As per the said guidelines, an applicant desirous to have a certificate declaring him the member of scheduled caste, scheduled tribe, OBC or MOBC has to move an application in prescribed performa through online mode by paying requisite fee. It is mentioned in the guideline that the caste certificate would ordinarily be issued within 30 days with a further extension of 15 days. With the reasons for extension of the said period. The procedure for granting certificate is also prescribed in the office memorandum, which says that the applicant has to submit application, online application form, and attach either a caste certificate, either the caste / tribe certificate of the father of the applicant, or an identification certificate issued by the authorized caste / tribe organization. It further says that the district commissioner of the concerned district where the applicant is a resident shall scrutinize the application, and when the caste certificate of the father of the applicant is enclosed / is found to be genuine and bona fide, the deputy commissioner concerned may issue the caste certificate to such applicant. It is further provided that in case of any doubt on the authenticity of the caste certificate of the applicant's father, the deputy commissioner shall cause an inquiry of caste certificate through the authorized caste or tribal organization. It is further provided that in case of any doubt on an identification certificate issued by the caste, tribe / tribe organization by the deputy commissioner, issued by the caste / tribe organization, then the deputy commissioner will cause an inquiry through the circle officer, which would be limited to ascertain the caste identity and not for production of data / document such as NRC papers, etc. The grievance of the in a full stop is further mentioned in the office memorandum that the any applicant who shall apply the caste certificate on false caste/tribe/community status would invite panel provisions, and the deputy commissioner may file FIR if there is detection of such false/fraudulent document. The essential remains raised by the petitioners in this petition is in respect of authorization of the all Assam tribal Sangha and its district units to make such recommendations for the issuance of caste certificate. It is noticed that earlier also the petitioner society has filed writ petition number, PIL petition number
30/19.
30/20.
30/2019, and the division bench of this court has disposed of the said PIL wide order dated 1/3/2023. In the said PIL, a similar concern was raised by the petitioners in respect of in notification dated 22/6/2009, wherein the president and vice president of all Assam Tribal Sangha and district unit of Assam Tribal Sangha were authorized to identify the status of scheduled tribe communities and to issue STP and STH certificates in Assam. However, the division bench of this court taking note of the notification dated 22/6/2009 has observed that the procedure seeking has observed that issuing caste certificates has observed that if the president and vice president of all Assam Tribal Sangha and district unit of Assam Tribal Sangha are authorized to identify the status of scheduled tribes, and on the basis of it, if certificates are issued, caste certificates are issued, then the said process cannot be said to be contrary to any provision of any other law. However, the division bench has clarified it that any certificate issued by the president oblique vice president of all Assam Tribal Sangha and district unit of Assam Tribal Sangha would itself will not mean that the caste certificate of a scheduled tribe would be issued only on that basis, and the authority concerned, that may be the district commissioner or the deputy collector or revenue subdivision authority, shall also make their application of mind based upon the material that may be available for issuing certificates. Full stop. The relevant observations made by the division bench of this court in the order dated 1/3/2023 are reproduced here under para number 7 and 8, page 83. In view of the above, we are of the view that even if the state government has authorized the all Assam tribal Sangha and its district units to make a recommendation for issuing a scheduled caste certificate. Wide notifications dated 16/3/2024 and 27 June 2024 cannot be said that only the tribal Sangha, only the said tribal Sangha and its district units have been authorized to issue the caste, scheduled caste, the scheduled tribe certificate. In the notifications itself, it is mentioned that the said recommendation is only to be considered It is also to be noticed that in the office memorandum dated 8th of August 2022, it is also, it is specifically mentioned that the district commissioner, the deputy commissioner, by issuing any caste certificate, will cause an inquiry, shall cause an inquiry of the, cause an inquiry and then only cause an inquiry of the caste certificate and then only issue the said certificate. In view of the above, in view of the above discussion, in view of the fact that the matter regarding issuance of the caste certificate has already been adjudicated by this court earlier in PIL filed on behalf of the petitioners, and it is and the court has held that if the recommendation made by a tribal Sangha or its district units can be taken into consideration, we don't find any merit in the challenge of the petitioners to the notifications dated 16th of March 2024 and 27th of June 2024. Hence, no relief can be granted to the petitioners in this PIL petition. The same is therefore dismissed. However, we made it clear that the respondents, the authorities who are authorized to issue caste certificate are required to
Caste certificate and tribe certificate.
caste certificates for scheduled castes, scheduled tribes, OBC and MOBC has to strictly follow the procedure laid down in the office memorandum dated 8th of August 2022.
Item 21,
May I please, Worships? This appeal is preferred against the judgment and order dated 5/1/2023, Lordship, passed by the learned single judge, Lordship. Appellant is Director of Central Preparation Research Institute, Lordship, Kasaraghat, Kerala, Lordship. In short, CPCRI, Lordship. CPCRI conducting on research and education on plantation or crops. Plantation of crops. The nature of the nature and function of CPCRI is purely research oriented, Lordship, and not connected with any commercial, industrial, or factory work. It is not connected with the function within the meaning of agriculture or sericulture farming. Therefore, CPCRI is neither an industry.
We'll read this. You have already mentioned in the petition, we'll read this.
Lordship. And
You
Lordship,
you are asserting the impugned order of the learned single judge. How it is wrong?
Lordship, that is,
You have
Lordship,
already mentioned in this pleading.
Yes,
Pleadings
Lordship.
will read. How this finding of the learned single judge is wrong.
it is at page 60, Lordship.
60.
Judge 160, Lordship.
Yeah, what is it?
A reading of the provision of part 2, schedule 1 of the Act, Lordship.
Yes.
Actually, Lordship, my case is very simple, Lordship, whether it is fall under part 2 of the schedule property.
That's
of-
what the learned single judge has said. Yes,
Yes.
it comes within that.
Yes, I am saying it is not within that.
So you are saying, but on what basis you are saying?
It
The
is,
learned single judge has already made an observation. Read para number 7.
because we have not selling any product, Lordship.
That is not only selling is not necessary.
We do only research of, Lordship.
That's why only the single judge interpreted that and or and also this take into consideration the including para also, that the word including mentioned in the definition, and come to the conclusion that this means that not only this any other activity including the marketing and all would be treated as agriculture activities.
So from my understanding, Lordship. it is
Your
not called-
understanding, madam, you assail this order, you are assailing on what, any other law in your support? Any other law?
Then, Lordship,
So you are appealing for whom? Chaudhary,
The last respondent, labor. Other input order. From there, they have further repetition. They have all.
Respondent number 16.
madam. What is your basic argument?
My basic argument is this is, Lordship. Since findings of the learned single judge, whether it is industry or not, it is, Lordship. I am on the view
It
that
is not the finding of the industry. They are not saying it is industry.
but learned labor court has said, Lordship.
Labor code? There
Yes,
is a
sir.
labor code.
Labor court, we have challenged the writ petition. In writ petition, the labor court order, Lordship.
Are you sure?
Yes, Lordship.
Are you sure?
Labor court has stated, Lordship, kindly peruse.
Are you sure, madam? It's a labor
In-
court order.
No, initial order was labor court was central.
Okay.
Thereafter,
Have
we
you gone through the brief?
Yes.
Where is yes?
central labor court, then we have filed writ petition, Lordship. Now I am coming against the order of the writ petition, Lordship.
Madam, first of all, you please verify the order which was challenged before the learned single judge of which authority?
I am challenging the single judge's order of the writ petition, but writ petition is filed against the
Madam,
order of the labor court, Lordship, page
not labor
131.
court, madam. Authority under the minimum wages act.
Sorry, so I'm very,
Oh, you are sorry. That's great.
page 131, Lordship. Page
Be
131.
prepared with your brief. You are not aware
Page-
of what is the
page-
position.
Page 131, kindly see, Lordship. They have stated it is lordship.
Madam, it starts from page 120.
Yes, relevant portion is 131 lordship.
11 portion, now how you are, this relevant portion, they have taken into consideration and said okay, it is not an, this research institute only.
Not only the research.
It is very much covered under section 2 of the Minimum Wages Act.
Lordship, some other day I shall satisfy lordship.
Madam, many other day, what else?
Third day maybe given lordship, I shall.
Do you have any authority? Have you ever searched that the Supreme Court or this court
Yes,
or any
one
other
order
court
has been
has?
reflected in the judgment also lordship. Yes. Yes.
Which judgment reflected?
I shall satisfy lordship next date lordship.
Yes, Mr.
I am for a private respondent.
Your private respondent, you have to satisfy this is a research institute. Oh, until and unless it is involved in some marketing or something, how can you, it's purely a research institute.
Marketing part is also inclusive with the.
But it's only a research institute, they are researching in respect of crops and everything. How can you treat it as a, this institution covered under section 2 of the Minimum Wages Act?
So far the schedule.
It is not a factory or any establishment.
Establishment, it is an establishment with
Research institutes.
research institute, but it involves in the, so far the scheme is concerned.
Requires some consideration.
So far,
Sorry to say, you are not at all, you have not even looked into the matter. What is the matter is? You are simply reading from these pleadings that we will read this. Where is the research?
Next is lordship.
Minimum Wages Act है ना? Be prepared.
Lordship, on judgment, Lordship, I want to place next date, Lordship, 1998, 1 GLR 218.
Being heard the non-constitutional. Parties and after going through the material available on report, we are of the view that the matter requires considering, hence admit. Put up in due, no need to issue notices, parties are already in present, put up in due course.
Apology.
Item 25.
22 again.
May it please your lordship. Lordship, the appellant has preferred this writ appeal, my lord, challenging the order and judgment dated 23/4/2024. My lord. Lordship, kindly peruse. Page number 99 of the writ appeal, my lord. Here, my lord, para 13, my lord. Emphasis was laid on, my lord. May I read, my lord?
Yeah.
My lord, para 13, my lord.
Page
Page 99, my lord.
29. Yeah.
May I read, my lord? Further, it is to be noticed that the petitioner was discharged from service on 30/4/2004, and after a long lapse of around 20 years, this court would not like to venture to direct the respondent authorities to provide the petitioner an avenue of employment against any post, my lord. But, my lord, the petitioner hearing, my lord, is fighting the litigation, my lord, from 2005. From 2005, he is fighting, my lord, for his right, my lord. My lord, the entire case of the petitioner is that, my lord, after being enrolled in Assam Rifles, my lord, while undergoing training, my lord, he sustained injuries, my lord.
Yes.
And thereafter, his treatment was prolonged, my lord. Thereafter, when he was fit to join the service, my lord, he submitted representations before the respondents, my lord. Thereafter, my lord, they have discharged him from service, my lord, saying that he is not qualified to become a combat soldier, my lord.
On account of
Thereafter,
some injury and all.
yes, my lord. Thereafter, my lord, the decision was challenged before this honorable court, my lord. This honorable court, on the last round of litigation, my lord, directed the respondent to constitute a medical board to examine the case of the petitioner. The medical board has found that, my lord, the petitioner is fit for the civilian nature of duties, my lord.
Was fit for normal duties.
Normal duties, my lord.
You know, then
So, my lord, my only contention is that, my lord, he may be adjusted in any kind of civilian post, my lord.
now the question comes, okay, after 20 years. That's why only the learned single judges decided the matter on merits that why your claim for another post can't be taken into consideration, and this was an additional, in addition to that. This was not the only reason for that. The learned single judges dismissed your claim. How this finding of the learned single judge is wrong.
My lord, he is fighting the legal battle from 2005.
Legal
my
battle,
lord.
yes, you're right. But is there any merit in that legal battle?
At least some consideration may be given, my lord,
What consideration, sir?
that he may be adjusted in
The consideration
civilian
is
post,
that
my lord.
will not pass any order on merit, you withdraw it. That would be better. Otherwise, the can't.
No, in that case, my lord may do whatever it deems fit, my lord.
Okay, fine. This writ appeal is filed by the appellant being agreed with the judgment and order dated 23/4/2024, passed by the learned single judge in writ petition number 4756/2014. The petitioner, the appellant has approached the writ court challenging communication dated 2/8/2013, whereby based on the review medical examination, the discharge of the petitioner from the services of the Assam Rifles wide order dated 31st of October 2004 was upheld, and his prayer for disability pension was rejected. Learned single judge is However, the learned single judge has dismissed the writ petition by a detailed order, by the impugned order, while giving the reasons in detail. Full stop. The brief facts of the case after the appellant was selected and thereafter enrolled in the Assam Rifles on 26/12/2002 as RFN/GB he was the appellant was thereafter sent for training. However, during the course of training, he suffered an injury on his leg, identified as sustained stress fracture, and he was treated in various hospitals. But during this process, the appellant missed his training for around 183 days. Would stop. The authorities of the Assam Rifle Training Center and School, Dimapur, has assessed the condition of the appellant and discharged him from the services, discharge him from the training wide order dated 3/4/2004. Being agreed with the same, the appellant has approached writ court by way of filing writ petition number 7546/2005, which came to be disposed of by this court on 23/4/2013, following the decision rendered in writ petition number WPC 1806/2012, decided on 10/8/2012, and directed the Assam Rifles
Hmm.
to constitute a fresh appellate medical board to examine the petitioner, to examine the appellant. The fresh medical board submitted its report, which suggests that the appellant cannot be. The appellant is only fit for normal duties and not for combat operation, but, not fit for discharging duties as combatant soldier. Taking into consideration the said report, the Assam Rifles has affirmed the discharge order of the appellant. It is noticed that before the writ court, the appellant has prayed that as per the fresh medical report, if he is not fit to discharge duties of a combatant soldier, the respondents be directed to assign him any other duty in the organization. The learned single judge has also has rejected the said prayer of the petitioner, taking note of the provisions of the Equal Opportunity / Protection of Right and Full Participation Act 1995, relating to the persons with disabilities. The relevant portion of the impugned order passed by the learned single judge is reproduced here under this para number 8(2), impugned order का para number 8(2), 14 का. Having heard the learned counsel for the parties and after going to the material available on record, we are of the view that the appellant has, the counsel for the appellant has failed to persuade us to take a different view as has been taken by the learned single judge in the facts and circumstances of the case. Hence, the writ appeal is just.
Deeply obliged.
Twenty-six.
Lordship has pointed out that there is a prohibitory order, Lordship, that for the earlier case, Lordship, 16/2021. Had it been passed in 2021, Lordship, it would have been better, Lordship.
That's it.
Lordship, in the meantime, Lordship, it is a no doubt this is a good order, Lordship. No doubt this is a good order. Had it been passed in 2021, all other constructions that have been continuing.
Okay, what punishment now they are required to give?
No, Lordship, not any sort of punishment, but Lordship, some constructions were going on during that period, Lordship.
Regarding the illegal use of that land.
Lordship.
They have issued the prohibitory order.
Lordship.
There has
been some encroachment.
Grievances now.
Lordship, some encroachment had already been made, Lordship, during that time also, and the honorable.
What encroachment?
Lordship, some constructions are there over. That is why,
What construction, sir?
that is why I wanted to file a reply, Lordship, to
Sir,
bring in.
where in the PIL, you have mentioned that these constructions are there.
Lordship,
Where is that?
Lordship, that by a way of Lordship reply, I wanted to bring the photographs, Lordship.
Sir, photographs, then you should have filed it earlier in the PIL itself. I'm not mention anything in the PIL. Now you want to
Lordship,
change the.
I didn't know, Lordship, I didn't know that they would pass this order of the earlier, in the earlier one, Lordship, I placed photographs. In 2021, Lordship, I had the photographs there, Lordship. But they passed that order, they passed after 4 years, Lordship. I understand, Lordship.
Now, more or less, the purpose of filing this PIL is.
Lordship, just, and Lordship, this Lordship, this is like a 144 order, Lordship. It will be valid for magistrate order, Lordship, for 6 months. And after that, again, the same thing will happen, Lordship.
After that, you come again.
Again.
Again, I will come, Lordship.
Again, you are not required to come, sir. If it is the order that they'll take care of that, they'll do that.
Lordship, one thing, Lordship.
Yes.
In the earlier order, Lordship, page
Just for
16.
the sake of, sir, please get it disposed of. Naya case law.
Lordship,
Why to?
I want it to be
neglect
disposed
this
of.
case only.
Lordship, just one line, Lordship, that illegal encroachment that had been done over there, as per the earlier order, Lordship, that should be evicted, Lordship.
Which is that earlier order? What?
Page 16, Lordship.
Yeah, read.
Second last para, Lordship.
Yes.
Page 16, Lordship, second last para, last lines. In case there is an encroachment on the grazing ground, the same has to be removed.
This is already there.
That is not there, not in this.
This
Yes,
direction is already there.
It is very much developed. It is only specifically the petitioner has made in his prayer that it is with regard to that erectment of some pandals which has been done, and all thing has been addressed in that letter.
For the marriage purposes,
Yes,
Lordship,
these persons are raising pandals and they should be stopped.
Lordship.
and that
In a
thing has been
way,
addressed.
in a way, in fact, though it's a public purpose, but also you are against the public purpose. Also.
Yeah.
Where the poor man will go? For the purpose of this marriage and all.
Lordship, this is
He
a
can't
village-
book any
this
these
is a
resorts and
village area,
gardens
Lordship.
everywhere.
This is a
So
village
if
area.
they
Lordship.
are using this ground for the purpose of this marriages for 1 or 2 days. this is
No,
also
Lordship, they are
against the-
starting a business. That was the problem, Lordship. They are starting a business over that land, Lordship. For one purpose,
the
I would
person-
not have come, Lordship.
Who the persons are running the business there?
Lordship, there.
Nowadays, the marriages are so costly. Every person can't afford this
Lordship, in the earlier
resorts
case,
and all.
in the earlier case, Lordship, I had pointed out that there a community hall was being built under construction, Lordship, and it has remained there, Lordship, still till date, Lordship. The marriage hall that was constructed over the land, it has not been dismantled, Lordship. It is there, it is still existing. And since the order is passed in the earlier case, Lordship, I cannot point out in this present case, Lordship.
Okay. This PL petition is filed by Appella. Whereby the petitioner seeking the release, page number 10 to. Stop. Please notice that earlier also the same petitioner,
No, Lordship, different.
it is noticed that earlier a PIL, earlier one Pankaj Lochan Vaishya has preferred that PIL number 16/2021 before this court claiming the similar reliefs as played for in this PIL petition. The said PIL was disposed of by the division bench of this court by the order dated 23/2021, directing the district commissioner Kambu to look into the grievance of the petitioner and after giving notice to all the concerned parties, pass appropriate orders in accordance with law. If need be, the orders of the eviction, if the same is required, the order passed by the division bench of this court in PIL petition number 16/2021 is reproduced here under page number 15.
Lordship, one second, Lordship. There also, Lordship, about the community center, I am stating, Lordship, that is there in the order, Lordship.
We have read that, that's why only we have quoted it.
Lordship, that should be quoted.
Again, the petitioner has raised, that now the petitioner has raised this grievance that despite passing of the order in the earlier PIL on 26/3/2021, the state authorities has not acted, has not taken any action, and the land in question is being used. And the cattle grazing ground in question is being used for commercial purposes, for arranging marriages and other programs. Full stop. Reply to the affidavit in opposition is filed on behalf of the district commissioner, Kamru, wherein is mentioned that pursuant to the order passed by this court in PIL, this court on 26/3/2021 in PIL number 16/2021, a prohibitory order under section 163 of the BNSS is already issued on 7th of February 2025. The copy of the prohibitory order is annexed with the writ petition as with the affidavit in opposition as annexure A, which is reproduced here under para number, page number 32. In view of the fact that the prohibitory order under section 163 BNSS has already been issued by the district magistrate Kamru, no further order is required to be passed in this PIL petition. However, it is expected that the respondents shall act to remove the encroachments any made on the cattle grazing ground as directed by this court in PIL number 16/2021, decided on 26/3/2021. These observations, this PIL petition is disposed of.
Not so late.
Item 27.
Lordship, this appeal was filed against the order of the single judge. Lordship. Impugn order is at page 30 to 49, Lordship.
Essentially, you are seeking provincialization of your services.
Yes, Lordship.
Under the provisions of this 2011 Act.
Yes, Lordship.
How can that act already been declared as unconstitutional void?
Lordship,
Can't be done.
Lordship, our school has already been declared eligible.
Eligible only, it was a recommendation. It was
Yes.
not final. This provincialization was not granted finally. It was only a declaration.
Lordship, as per this, as per section 4,
Yes.
Lordship, it is deemed to have been this provincialized.
That Learned single judge has no deeming because another judgment is contrary judgment is there.
Lordship, our own High Court single judge judgment is there, wherein the
That is
DB.
also of our own High Court. Another judgment is also of our own High Court.
Lordship, that delete this judgment has relied on a decision of the double bench judgment of in the review petition 167,
But,
Lordship.
now the Honorable Supreme Court has already, in this Okram case, they've already said that once the act is declared as unconstitutional,
Lordship, the relief can be, it is also this Raymond case, Lordship, the relief can be given to them, sir. Lordship, because we have already, out of 10 petitioners, Lordship, 5 petitioners has already been
having
retired.
heard the learned counsel for the parties, we are of the view that matter requires consideration, admit. No need to issue notice, these parties are already represented. This, what, this will be appeal for hearing in due course.
Of that, Lordship.
Item 28.
In this matter, I appear on behalf of Mr. H. Chakraborty, Lordship. He could not come today, Lordship. So I bring that
Suppose filed and rejoinder,
it has been filed, Lordship.
rejoinder has not been.
My lord, we also praise some time, my lord, to file a reply against the rejoinder filed with the petitioner, my lord.
As per the office report, reply affidavit filed by the petitioner is on record, no rejoinder is filed.
I'm sorry then, Lordship. I'll have to check it up.
And in counsel appearing for Mr. So and so has submitted that the arguing counsel, Mr.
I am MP Sharma. I appear on behalf of A. Chakraborty.
Arguing counsel, Mr. A.
Chakraborty.
Chakravarti is not available today. He placed some time to, therefore matter may be adjourned. It is noticed that rejoinder, I think, so.
Oh, it was filed on
My lord, rejoinder filed
January
is the month of January, my lord.
Just after 3 weeks. Simple letter, like that, let's-
Item 30.
In this case, in Honorable Court order, as per the matter, we have joined in the respective place of posting. It is disposed on, my lord, this is IA
Admit it,
834.
admit it. Having heard the.
My lord, by this time, I may be allowed to file an additional affidavit to bring this, all these things to the record. Master.
Counsel for the parties. Fear of the matter requires consideration, admit. No need to issue notices, parties are already represented, list for hearing in due course.
My lord.
Item 32.
Lordship, in this case, Lordship has asked me to produce the record. I have got the record, Lordship, but the records are for the current selection. What will be relevant of 2015 selection? Because we took
This
this
is relation to,
appointment promotion, Lordship.
this record is,
Current, the last selection which is for which we have denied the appointment to the respondent. So our stand is that one post in 2015 filled by Imran D. Shira, who is a ex-T candidate, he got selection on his own merit. So that marks will be relevant. To 2 weeks time, Lordship may grant me to produce that record. That will be the relevant record, Lordship.
and we produce and record along with the affidavit, whatever. Mr. B. Chakravarti. Take some more time to place the relevant record. To place on record the relevant, to place the relevant record before this court. Just up to 4 weeks,
All right. Item 33.
6 weeks.
May please, your lordship, my lord.
Malad, here the petition, Malad, is, Malad, Agniveer. Now, Malad, thing is that, Malad, whether accident and sick, Malad is the same. They say the eye sustained injury during the training attributable to the military service while in duty, my lord. And the sick means is something itself, my lord, by infection of virus, fever, like that. So,
Say so, sir. What
yes, that the rule there, my lord. But now they filed the affidavit. They have accepted that I, my lord, joined on 13/3, page 126, para 3, my lord. And the discharge on the 12/4. That period has not been calculated in my humble submission, my lord.
That is not required to be calculated.
My lord, they say, my lord, kindly say, my lord.
That this, kindly see, sir,
Yes,
to raise the order of this tribunal.
yes, yes. That relevant portion 121, my lord. The calculation, my lord.
121.
Yes, calculation, my lord.
Is another thing. This calculation is very much there.
My lord.
But what they have said in this,
In the affidavit, my lord, they have accepted.
on the contrary, the learned counsel drawn tribunal the petition laid on the individual missing more than 30 days
Yes.
of community training for any reason will be liable to be released, and calculation 21, consequently 30 community missing counsel shall be absent will be included. Admission in hospital including attempt to sick leave, absent without leave, executive Sundays and holidays other than training to organize activities that
Now, kindly, my lord, that impugn order at page 48, my lord. They have constituted it to be as missing from training.
not missing, but in fact, you were admitted in the hospital, the tribunal has taken into consideration this. But
My
they
lord.
said it is more than 30 days, we can't help because the rule says so.
My lord, therefore, that our affidavit in reply, we have filed, my lord, there. This is the, my lord, terms and condition of this Agniveer service. My lord, now that 140 page, my lord.
140.
Yes. my lord. That this is for terms and conditions of Agniveer scheme.
Yes.
Agniveer engagement 140, seal number 8, my lord, leave. That includes sick leave, my lord.
Sir, but ultimately, apart from that, they have simply said more than 30 days missing for any reason. Can't be treated.
On that, my lord, my argument would be, my lord, to consider two Supreme Court decision. Whether
Then you have to, sir, then you have to challenge these notification itself that this provision
My
of
lord.
not exempting this
sick,
sick leave or attendance in the hospital for any reason, that is not in consonance with the law, sir.
my lord, my humble submission, my lord, I pray that there is a distinction between sick and accident. For accident, you cannot constitute to be sick. My lord, that, my lord, they have accepted that I made an accident while in my lord, training. That is admitted position, my lord.
Sir, no doubt. That is what you have now, you were sitting here, that Assam Rifles case.
My lord.
That person also got injured during the training, despite that they have released in form service, because these are some standards are different. It is not like a normal service, sir.
My lord, however, my lord, whether coming to the conclusion whether I am missing or sick, my lord, for the purpose of accident, whether they can constitute to be a sick, my lord.
Admitted, yes, you are not missing.
Accident.
You are simply going under treatment.
On their own doctor advice.
Sir, what do you mean by sick and hospitalization in case of accident?
My lord, this distinction.
Sick.
Well, the distinction is there. Well.
That is, you can't differentiate such a, that sick means only a person is suffering from fever and all.
Yes,
Sick
Malab, this
means
is,
sick.
and Black's Law Dictionary also says this, Malab. Accident, something which is beyond his control, within the duty. And a person,
That's why only said you challenge these, whatever the rules, you can't have such type of.
Malab,
rules where
kindly
you-
one day, Malab, you hear this matter, Malab, one day, Malab, I will place 3 judgments, Malab, just for one.
Yes.
Malab. I think you know.
Having heard the learned counsel for the parties hereafter, that matter requires consideration.
Right.
However, looking into the fact that the petitioner is out of job without admitting the petition will listed for here, will listed for final disposal in the month of
Malab,
June.
first week, Malab.
June.
Malab.
You take the date from the register.
Malab. Obliged, deeply obliged.
Supplementary list, item 34.
It's a tender matter, my lord.
Mr. Chaudhary,
Lordship.
what is the difference between these two certificates which he has submitted? What is the difference between these two certificates? You are claiming that this is one is the performance certificate and another is this work completion certificate, and therefore he has not complied with this performance certificate. What is the difference?
Lordship will kindly come to page 66 for a moment, Lordship.
Sir, you please come to this first of all.
This certificate, Lordship, page 66
No. This page 66 of what?
of the appeal, Lordship.
No, just come to this internal page 6 of the impugned judgment, where the learned single judge has placed reliance. Para number 12 of the judgment.
Yes,
This is one certificate.
this is one certificate.
Here, this is work, the work completion certificate, construction of so and so, so and so, so and so. Under which the petitioner's performance has been judged, which is reproduced here under as follows.
Yes, Lordship.
This is the one certificate,
Yes, Lordship.
and the another certificate in para number 14.
No, this is, no, I get your Lordship. He has submitted, he is required to submit 3 certificates in different categories. In one category, where he is required to submit 2 certificates, that is why I'm taking your Lordship to page 66.
66.
66. What is reflected in paragraph 12, Lordship will find at page 66.
Yeah.
This is one certificate at page 66. And Lordship will come below. There is quality of work indicate grading. Lordship has got it.
Here in this,
Yes, in page 66.
yes, 66.
Yes, there is a Roman
Name of
one.
the work,
Yes,
name and address of the work order number, date, tender value,
no,
missing-
Lordship, below.
below.
Is it,
Major items of the work. This,
Lordship, in my, it is page 6.
sir, it's the work completion certificate.
It reads work completion certificate.
To him, it may
Yes.
concern.
Yes, Lordship.
And construction and upgrading of river works along with Buri Dehang River
Yes,
to
that's the
reduce
same.
erosion risk package to lot 4.
Yes, Lordship, in that same page, Lordship will come below.
Below, yes,
Yes, Lordship will see quality of work indicate
quality of work indicate grading.
grading, Lordship.
Yes,
So,
very good.
so he has been graded. So in this category, he is required to submit 2 certificates. This is one certificate that he has submitted.
Fine.
And the next certificate, Lordship will see at page 68.
68. 68, yes,
Yes.
completion certificate.
Yes, Lordship.
Hmm.
Here, The grading is not there.
No,
The grading is not there, Lordship.
just a-
And for this reason,
just, you mean to say that this certificate at page 66 can't be treated as a performance certificate?
no, page 66 denotes his performance. It gives very good. In page 68, it does not describe his performance.
68 is in relation to other work,
Is in relation to another work.
another work.
So
This
here,
is just a minute. NH and this NH 52 worth something, you know?
yes.
Just- This page number 62 is the certificate of what?
Yes, page number 62, he has to give Lordship certificates in two categories. One is 80%. That 80%, he has to give one certificate, which he has given, that we have taken into consideration, which is at page 62. In another category, he has to give two certificates, where he has given one. If I may take your Lordship to the bid evaluation minutes for a moment, Lordship. At page 78.
70?
78.
Yes.
Lordship will see B1, that is the petitioner company.
Yeah.
Gautam Construction, so and so. Work experience based on documents submitted by the bidder. It is found that the bidder has submitted work experience document for work, improvement and upgradation of SH2 amounting to so and so, including so and so. Eligible as per NHA 23, 1A1, one similar works costing not less than 80% of the estimated cost put together. That is the certificate that your Lordship has seen at page 62. However, the bidder has failed to comply with the following requirements. NHA 20A 13.2 clause 2(1) of the bid, it should be 2I, it should be read as 2I of the bid document, as per which the bidder is required to submit bidder's performance certificate for any two works completed in the last 3 years. Now, clause 2I, your Lordship will find at page 47. After HI, bidder's performance for any two works completed in the last 3 years, ending previous day of the last day of submission of this bid tender, should be certified by an officer not below the rank of executive engineer, project manager, or equivalent in Form D. Now, he has submitted one certificate that your Lordship can see at page 66, which has made an assessment of his performance.
In relation to one work.
Yes, that is one work. In relation to the second work, that performance is not there.
performance evaluation is not there, which your lordship will see at page 68. And this is
That
the,
is a completion certificate.
yes. And not only him, lordship, another tenderer has also been rejected on the same ground. Another tenderer has also been rejected on the same ground. lordship.
My lord, my lord, your lordship will see, my lord, the tender committee has said we have submitted only one certificate.
In
My lord,
relation to
they
what?
have not considered this 68 page 68. They have not considered. Now in the court only, my lord, my learned friend said that that was not a performance certificate. Now, lordship will see page 68.
Page
68, the second
68,
certificate.
yes.
What is the performance, my lord, that your lordship may come to line number 3.
Yes.
The work has been completed in all respects as per specifications and provision and to the satisfaction of the department. In the bottom, overall physical progress 100%. What more is required, my lord? What is the performance certificate? Is it not a performance? I have not performed the work. I can show my Black Law Dictionary and other judgment also. After 4 months.
But what about this quality of work indicating?
Well,
grading?
that is completed in all aspects as per specification. As per specification and provisions. And to the satisfaction of the department. What more is required, my lord? I do not understand, my lord.
You just see,
My lord,
no, just, here this page number 62, which you have.
page 60, my lord, that was immediately
62,
completed.
62.
Yes, 62, yes.
It says work performance certificate.
Yes, that was, my lord, different. That was a, my lord, for
And here
80%.
it says completion certificate.
No, well, the 64, which is there, 66 they are accepting, that is also work completion certificate. 66, which they have accepted, that is also work completion certificate.
No, here this grading is there already.
No, grading, my lord, this is more than that, my lord. What I am submitting, technically, my lord, what was said, what is performance? Performance means I have completed the work in all respects.
No, Mr. File your reply. You have not filed any reply before the writ court?
Lordship, it was disposed of in the motion status.
You are for?
He is assisting me, lordship.
And the notices were not issued to the respondent number 7 and 8.
No,
No, lordship.
Why?
not. They say
They are
it
the-
can be disposed of.
Issue notice to the respondent. Mr. RKD Chaudhary put an appearance on behalf of the respondents number
1 to 6, my lord.
1 to 6. lordship.
1 to 6.
Yes.
Let notices be issued to the respondent number 7 and 8. Returnable on 9th of June. Registered AD and Dasti. Is made clear that any proceedings pursuant to this tender notice is what?
Yes. Then annexes 1, my lord, I am telling you.
Tender notice,
But
which is annexed as annexure 1 in the writ petition, shall remain subject to the outcome of this writ petition.
Lordship, I may just inform your lordship. In the meantime, the work order has been issued, but that will be subject to outcome.
Subject to outcome.
To oblige, lordship.
Let them find their response.
my lord.